Welcome to the Hearsay podcast, a joint project between Pro Bono Students Canada at the University of Calgary and CJSW 90.9 FM. I'm your host, Emilia. Before we introduce today's topic and esteemed guest, here's a quick reminder. The information you're about to hear today is not legal advice. This podcast is for educational and informational purposes only. There's no substitute for a legal professional, so please consult a lawyer if you require legal advice. With that out of the way, let's get started. In October, Albertans will vote in a provincial referendum. Among other things, 4 of the questions are regarding our Constitution. As law students, we spend a lot of time reading about these division of power disputes. But today, we want to step back and look strictly at the mechanics of how a referendum actually works and what it truly takes to change the Constitution. Joining us to cut through the political noise and provide much-needed context is Professor Emeritus Nigel Bankes. Professor Bankes taught at the University of Calgary's Faculty of Law for nearly 4 decades, from 1984 until his retirement in 2021. Throughout his career, he became a leading authority on natural resources law, energy law, and Indigenous law. Beyond the classroom, his expertise has taken him from serving as a professor in residence for Canada's Department of Foreign Affairs and International Trade to advising federal and provincial governments on complex issues such as modern treaties, water, oil and gas, just to name a few. To start us off, I want to lay a foundation for our listeners who might not have a background in law. We hear the word constitution thrown around a lot during election cycles. Can you walk us through what the Constitution of Canada actually is and where we can find it?
The Constitution is the supreme law of the land, and we find it in a number of documents, basically. We find it in the old British North America Act of 1867 that created the original Confederation of Canada, now known as the Constitution Act 1867. And we find it in the Charter of Rights and Freedoms of 1982. But there are also other constitutional instruments, some of which relate specifically to Alberta. So, for example, the Natural Resources Transfer Agreements of 1930, which afforded Alberta control of its resources, are part of the Constitution of Canada. And there are also unwritten principles, and we know that the documents that I've referred to deal with the creation of Canada. They deal with setting up Canada as a federation, the roles of Parliament and the House of Commons and the Senate. And the Charter deals very much with the relationship between the state and individuals. So incredibly important documents, but then also some unwritten principles, constitutional conventions and important decisions of the Supreme Court of Canada that establish additional rules, one of which we'll talk about later, I think, the paramountcy rule in the Constitution. So that's good enough for an intro, I think.
For sure. Yeah. So now that we know where it is, how does one go about changing it? Are there different ways or requirements?
Well, the first thing is to say that constitutions shouldn't be easy to change, right? They're the fundamental law. They're designed to lay out how we're going to live together over a long period of time. So statutes can be amended just like that. The Constitution can't. And yes, we established different rules, and we find them in the Constitution Act of 1982. Different rules depending upon the significance of the provisions at stake. So the general rule is that if you want to amend any provision of the Constitution, so this is just the general rule, you need 7 provinces representing 50% of the population to tabling resolutions in favour of the amendment. So that's the default rule. The other rules are unanimity, where you're changing really fundamental provisions in the Constitution, including any changes to the amending formula, right? If we're going to change the rules on that, we require unanimity. And then there are some provisions of the Constitution, like the Natural Resources Transfer Agreement, that really only apply to Alberta and Canada. So they could be amended by agreement or resolution of both the province of Alberta and the government of Canada. And I should add something to the unanimity rule and the 7+50, and that is we also require resolutions in support from the House of Commons and the Senate. So it's House of Commons plus Senate plus 7 provinces representing 50% of the population. So that's the default rule.
Now that we have established the default rule, how do we actually start the formal process of amendment?
Well, what the Constitution says is that the process starts when any House of Commons or Senate or provincial legislature tables a resolution proposing an amendment. And then, if you like, that triggers other provinces, other jurisdictions to pass a similar resolution. But of course, those things don't typically start in such an abstract way. One would expect that there would be meetings, maybe even a big constitutional conference. So, the last major change we attempted was the Charlottetown Accord many decades ago now, and that was preceded by a series of constitutional conferences that took place over about a 6 to 9 month period. So trying to get agreement on a text. So the formal process starts with a resolution. The background to that resolution, you'd have to think, should be a lot of hard work to try and figure out if we've got consensus or anything like the 7+50 that you need to be successful.
Thank you for that explanation. So we don't necessarily need a yes vote in a referendum to get started, correct?
Correct. We don't need a referendum at all. Government, each individual government can decide what they would put in place before that resolution was introduced. So what I was talking about is what the Constitution says about that process. Each of the provinces, the federal government, could decide what process it would put in place, and so might well require a referendum, but there's nothing in the Constitution that says before a provincial government signs onto a resolution, it must have a referendum. I mean, the referendum process really started with the Charlottetown Accord, but there's nothing in the Constitution that says you have to have a referendum.
If that's the rule, what does a yes vote in a provincial referendum regarding a constitutional question actually entail?
So we have a statute in Alberta called the Referendum Act, and it distinguishes between constitutional referenda and other referenda. And what it says for a constitutional referenda, so some of the questions that Premier Smith plans to put before voters in the fall, is that if a referendum question is adopted, in other words, a majority, 50% plus 1, then that resolution is binding on the government that initiated the referendum process. So in this case, it would bind this UCP government. It's not an attempt to bind anyone beyond that, and the statute also defines bind, so it doesn't really mean binding. It just requires the government to use good faith, best efforts to initiate the process of formal amendment, which is what we've been talking about. So it's not a normal use of the word bind. It's a diluted version of binding, and it's certainly not legally binding. It's binding at a political level on the government that initiated the process.
Okay, we talked about the process in a bit of an abstract, so let's apply it to actual ballot questions.
Okay.
So one of the first questions is about abolishing the federal Senate. So which of the amending formulas would apply here?
Well, in this case, we've got some pretty clear guidance from the Supreme Court of Canada, because the Supreme Court of Canada was asked to weigh in on this several years ago in what was known as a reference case. So one of the questions it was asked is, what is the amending formula that applies to abolition of the Senate? And it came back crystal clear that that is such a fundamental change to the Constitution, because the Constitution is both provisions, but it's also structure, right? And one of the things we know about Canada as a federal system, at the federal level, we have a bicameral legislature. We have both a House of Commons and a chamber of sober second thought, as we put it, which is not an elected body, it's an appointed body. But the Supreme Court said if you take out the Senate from the constitutional process, you're actually amending the amending formula. And that's because of what I said earlier, that to get an amendment, you require resolutions of the House of Commons, the Senate, and 7 plus 50. That's done. But if you take out the Senate from that, then you are amending the way in which we amend the Constitution, and that triggers the unanimity requirement.
It makes sense why there's a higher standard. Another question asks if provinces should select the Superior Court judges or have more say in it. What amending formula is required to pass that proposal?
So the rule that says that Superior Court judges, so we mean by this the Court of King's Bench and the Court of Appeal, the rule that says those judges are federally appointed, it says actually appointed by the Governor-General of Canada, but we understand that to mean the Governor-General on the advice of the Prime Minister, which is an example of, an informal rule that controls that provision. But that comes from Section 96 of the Constitution Act of 1867. And that would be, if you like, an ordinary amendment, so it would be 7 plus 50.
Beyond the 7 plus 50 rule, what are some of the potential unintended consequences of this shift regarding perhaps the judicial independence?
Well, I'll say a couple of things about that. First of all, Section 96 it's a simple provision, but its interpretation has been incredibly complex. Because while it only speaks to appointment, it has been interpreted by the courts for over a century as effectively guaranteeing the right of judicial review of government decision-making. In other words, it's kind of capturing the separation of powers. And by the separation of powers, we mean we've got an executive, we've got a legislature, and we've got an independent judiciary. And the role of the independent judiciary, of course, is to pass upon the lawfulness of government actions. So you don't see a word of that in Section 96, but it's really the only guarantee that we've got of that separation of powers and the right to seek judicial review of government decisions. So one of the problems is if you mess around with Section 96, then what are you doing about these other principles that support Section 96? I mean, the second observation I'd make is that we do have the process of appointing Superior Court judges is not whimsical. It's not driven by politics to any great extent in Canada as opposed to the United States, and it's a consultative process effectively. So there is in place a committee that vets judicial appointment applications, and the committee is composed of the Chief Justice of Alberta or her nominee. It's composed of representatives of the Law Society, the Canadian Bar Association, so the key professional bodies. There is a nominee of the Attorney General of the province, the Minister of Justice, and there are several federal nominees. And their job is to pass upon the competence of folks seeking an appointment as a judge. And then the result of that is that names are passed on ultimately to the Minister of Justice and the Prime Minister, and the selection is from that group of people who are already, considered to be competent to stand for judicial office. None of that's in the Constitution. It's all, an important practice that has developed over the decades. And again, if you change this to be just a provincial process, well, what's going to happen to all of that? Are we going to get the same quality of what process will actually be put in place for those appointments to be made by the then Premier of the province? And I think, from my perspective, there's also something disturbing about what the Premier has said about why she wants to do this, which is that she wants judges who represent the values of Albertans. Well, we actually don't know what that means. Albertans have diverse values, and a judge's principal role, in fact, the judge's only role, is to apply the law to the facts of the case before them, without bias. Everyone comes to the table with values, right, and a background, but a judge has to try and distance themselves from that and apply the law to the facts as they see them. That's a long answer, I'm afraid, but Section 96 is it's a very it's a very short section, but there's a lot bundled up in it and a lot of practice over the years as to how we approach judicial appointments.
Thank you. As you said, there remains so many unanswered questions on how the process would look like. Moving on, what about the proposal allowing provinces to opt out of federal programs without losing funding? What is required to pass that?
Well, again, I think that would just be the ordinary process. So resolutions of House of Commons, Senate, and 7 plus 7 provinces representing 50% of the population.
Are there any programs that provinces can currently opt out of?
A province can opt out of any federal spending program whenever they like. But what they don't get is a right to the money instead of being part of a federal program. So we all know, for example, that there's significant federal money for health. But the conditions of that are that you live by the terms of federal requirements for health funding, which try and make access to the health system without fee and as publicly available as possible. So, that what we're engaged with here, when we talk about federal programs, is generally something called the federal spending power. And the federal spending power is another oddity because the Constitution doesn't mention the federal spending power, but it's understood that the federal government can use money and impose terms and conditions on the use of that money to achieve federal objectives, one federal objective being universal healthcare.
Thank you for providing such a concrete example. I think it helps our listeners to ground it in their reality. Now I want to pivot to the final ballot question, which is what actually inspired this episode. To help our listeners to understand a shift, could you explain how the current rule of federal paramountcy works? Like, what happens when provincial and federal laws clash?
Okay, well, let's sort of take a step back and say, we have a constitutional document of the 1867 Act, supplemented a bit in 1982, which says that the federal parliament can make laws in relation to a bunch of areas, like criminal law, for example, and the provincial legislature can make laws in relation to more local matters, property and civil rights. It can make laws in relation to the conservation of natural resources within a province. And so you get this idea that each can make laws, and that, as long as they stay within their heads of power, there won't be a clash. One won't have a conflict. But of course, that's not true, partly because some areas in which we make laws were not expressly addressed by the Constitution. And the classic example would be the environment. You don't see the words the environment anywhere in the 1867 Act. But of course, each of the federal government and the provincial government make laws in relation to the environment. For example, the federal government can rely upon its criminal law power to make a law in relation to the release of toxics in the environment. It can make a law to protect fish habitat because it has the fisheries power. But a province can also make laws in relation to the same sorts of areas. So there is the potential for a conflict. So the rule, though, is if each law is valid, in other words, it was passed based upon a valid head of power for that order of government. So the first question is, are both laws valid, right? There'll always be a preliminary question of validity. But if they're both valid, then the current rule is that the federal legislation, to the extent of the conflict, will prevail. And that, I think, is simply a reflection of the fact that we are a federation, that some of the most important powers for country building are things like the construction of interprovincial and international infrastructure, whether that's railway lines back in the 19th century or pipelines and transmission lines in the 21st century. So if you want to build a country and not a bunch of separate states, you need to know who can ultimately establish laws for that infrastructure without them being trumped, to use a current word, without them being trumped by one of the 10 provinces or 3 territories. So that's the rationale for a federal paramountcy rule. And as I hinted when we were introducing the Constitution, you don't find that rule in the written Constitution either. It's a judge-made rule. And so to overturn that rule, we'd have to draft a provision and add it to the Constitution. But again, I think that would be a House of Commons, Senate, 7 provinces representing 50% of the population. So it would be, in that sense, a normal amendment.
Just to follow up on that point, if Canada did actually add this provision and this law of, or rule of provincial paramountcy were to pass, could you give us an example of what could happen as a result?
I'm going to give you two examples, okay? Because you have to think, well, why would Premier Smith want to do this? And we don't know everything in her mind, but one example might be she's concerned about federal regulation of firearms, right? So there are rules in the criminal code, so the feds can regulate firearms under the terms of the criminal code, and of course the federal government, for good reasons in my opinion, has wanted to impose greater control on the use of firearms and to list certain firearms as not being available for use. One result of that is that people who own those categories of firearms are required to turn them in, which is, and in some cases with compensation, in some cases, I guess, without compensation. But in other words, it is from the perspective of some people a taking of property. So Premier Smith might say, well, we've got provisions in the Bill of Rights which protect property. And now we've got a conflict between a criminal code provision that requires the turning in of a certain category of property and a category of property that's protected by provincial law. Currently, and in my opinion appropriately, the criminal law power would trump. And that criminal law power would require the turning in of that property. So that's one example, which I think may be the type of thing that's motivating Premier Smith to come up with this proposal. The other example I'll give you suggests that maybe she hasn't thought about this proposal in quite the way that she needed to, because the second example I'll give you is TMX, right, the Trans Mountain Expansion Project, which Alberta was a great backer of, ultimately ended up being built with a lot of federal money. But the province of British Columbia, and certainly the residents of Burnaby and maybe other communities in the Fraser Valley and across the interior, weren't very happy about the expansion to the Trans Mountain pipeline. But that pipeline is federally authorized and federally regulated. It's authorized by the National Energy Board and its current successor, the Canadian Energy Regulator. But there were efforts to put roadblocks in the way of this, including by the municipality or city of Burnaby, which said, well, you're putting a right-of-way through, or you're expanding a right-of-way, or changing the right-of-way through the city of Burnaby, and we've got a bylaw that says you can't remove trees without our permission. A perfectly valid bylaw. The province can make laws in relation to such environmental matters, and it can delegate that authority to a municipality. But if that bylaw, just to continue the story, TMX, faced with these roadblocks, applied to the Canadian Energy Regulator to have it declare that the federal rule should be paramount, and that's what the CER ordered. And again, appropriately so. If you're building national infrastructure, you need a set of national rules for those construction projects. Yes, you should take account of local concerns and do what you can to manage impacts, but you can't give every province and every municipality what would effectively be a veto over particularly, I'd say, national linear infrastructure projects. But think about it. If we give the province the paramountcy power and its delegates, the city of Burnaby, we've just given all of those jurisdictions a veto, a claim to paramountcy over the federal regulation. And I'm guessing we wouldn't see much new critical energy infrastructure built if that were the case. So here's an example of a question which might look good from one perspective, firearms, doesn't look so good when you're dealing with its application in another jurisdiction that you don't control.
Professor Bankes, thank you so much for coming on the show and explaining these incredibly complex constitutional questions and mechanisms into something we can all understand before heading to the ballot box. That's all the time we have for today. Thank you for tuning in to the Hearsay podcast.